Good day and a very warm welcome to this training video. More specifically, we're going to talk about the Protection of Personal Information Act, or more reference to POPI or the POPI Act. And this is an employee training video. This is a first video of a three-part training video series. The first series, or this video, will focus us more on the overview of what the requirements of the Act is, and if you've got a committee overseeing or overlooking the information in your company, this video is specifically aimed at them. The second video will be looking at what is the way forward and what needs to be done, and the last video will then focus us more on just the employee side and what they need to know. This video is presented by myself, J.A.P. Kokemoer, representing J.A.P. Kokemoer and Associates, and we are standing for all compliance requirements within your organization. The presentation overview, I will try to make it very informative and very interactive. It's difficult not facing people, so hopefully I would make it entertaining for you guys to stay and to listen and learn from this presentation. First and foremost, we're going to look at the objectives, background to the POPI Act, where it comes from, and when it's actually going to go live. What is the POPI Act? What is the fines for non-compliance to the POPI Act? The pre-POPI Act practices of accessing information, compliance to the Act and requirements, and the institutional risks of access to personal information as an overview to this training video. And then recommendations will be summarized at the end of the presentation. Thank you for tuning in, and hope that you learn from this video. Now, personal protection of personal information. With personal information becoming more accessible and easier to manipulate, POPI legislation is imperative for the protection of businesses and of individuals' personal information. The types of organizations, the question be raised, which organizations have to comply in terms of this piece of legislation? No organization or business is exempt. Whether you are employing 10,000 people, 1,000 people, 50 people, or whether you a one-man show running a e-commerce business from your home, if you collect data, if you collect personal information, you have to comply to the requirements of the POPI Act. Regardless of your size, regardless of ownership structure, and regardless of whatever sector you actually are operating in. The Protection of Personal Information Act, again 2013, more referred to as POPI or POPI. It is there to protect our constitutional right to privacy by introducing measures to regulate the processing of personal information. So merely, how do we make sure that there's no information breach, and how do we regulate our businesses that there's no leakage of any personal information? It is also to ensure that South Africa is brought in line with the international legislation and what we conduct ourselves in a responsible manner when dealing with all personal information, including personal information about clients, whether we doctors, patients, employees, service providers, and the list goes on. Now, just a bit of history in terms of the POPI Act. In 2010, when we actually had the Soccer World Cup, the Europeans and the Americans and the international community were asking how you're going to actually protect our personal information, because you're going to ask our credit cards, you're going to ask detail, and what legislation do you have in place to actually protect our information? So the POPI or POPI Act was actually born in the 2010, and it is still not live, although the regulator has been appointed in 2016. this POPI Act will go live in 2021, this year, the 1st of July. What is the compliance to the Act? First of all, establishment of a new Directorate for Business Information. The role of the Directorate of Business Information is to monitor businesses, the processes, and to ensure compliance with the legislation. Also, understanding of the requirements by business owners and to provide amendments to business processes, thereby ensuring the fundamental rights of privacy within your business practices. Also, to perform personal information risk assessment of data subjects, and we will refer to data subjects and elaborate a bit more later. Implement and safeguard, have action plans to address risks identified, conduct POPI Act awareness and training, and this is why this training video is so crucial for the training of your employees, and investigate and resolution of reported privacy-related breaches. So on the end of the day, if there's a breach, how do we investigate? What's the resolution? And lastly, provide advice and guidance to POPI Act-related inquiries. The objective. This presentation seeks to explore how all businesses, and as I said, whether you're a one-man show and whether you're a big corporation, you have to comply if you do compilate any personal information. How businesses are impacted in the implementing of the protection of personal information, the POPI Act, with possible recommendations. It provides a platform for discussions of how other similar businesses are doing in implementing the same Act. The non-compliance to POPI. Institutions that do not comply with the POPI Act face possible imprisonment, terms and fines of 10 million, further financial losses due to legal proceedings, damage to reputation of the business, and lastly, the data recovery. The Office of the Regulator has been established and will be effective this year, as I said, July 2021. Compliance with laws and regulations. Now there's a whole list. We look at the Basic Conditions of Employment Act, Companies Act, Compensation of your Occupational Injuries and Diseases, QUEDA, Consumer Protection Act, Electronic Communication and Transactions Act, Employment Equity Act, Income Tax Act, Insolvency Act, Labor Relations. To continue with the acts repealing in terms of the POPI Act, it's the Occupational Health and Safety Act, Promotion of Access to Information, POPI, Protection of Personal Information Act, POPI, the Regulation of Interception of Communication and Provision of Communication-Related Information Act, the Skills Development Levies Act, the Unemployment Insurance Act, Value Added Tax Act. So to my audience then, let's look at some time limits on the POPI Act. First and foremost, as said previously, the purpose of the POPI Act is to protect people from harm, any form of harm. It might be identity theft or any other form of harm, and this by and will be implemented by the newly established information. The regulator has been appointed, and from that time, institutions would have a 12-month grace period. So last year, July, it was actually enacted and a grace period of 12 months was given. And we are at the period of 6 months sitting in January 2021 to become fully compliant. This means, ladies, gents, to my audience, there's limited time left to comply with the comprehensive requirements of the POPI Act. Ladies and gents, again, this is serious. This is driven by international law, by the ILO, International Labour Organization. So this is serious, and I would like you to really look at that in a serious note. POPI, a specific new obligation created by POPI is that once personal information has been collected from any source or any other source, the business must take reasonable steps. Again, I can can do whatever I want to. There's always the dark world. But what is reasonable? Steps to inform the employee of his or this, together with the source of the information and the purpose for which it has been collected. So at the end of the day, why do I collect your ID number? Why do I collect your name? Why do I collect your birth date? What's the reason for me collecting it? And what am I going to do with this information? This can be relayed to the employee whether either orally or in writing. I strongly suggest that everything we do it in writing. So at the end of the day, by getting the consent of your employees, there should be an addendum to the employment contract stating that they do give their consent in terms of the personal information you're actually going to require and for what purpose you're going to require it, and also make them aware that there is a privacy policy in place. They are aware and that they have familiarized themselves with the privacy policy. Carrying on with POPI, any personal information you hold must be protected from loss, damage, or unauthorized distraction and unlawful access. You will be able to expect it by law to implement reasonable, again the emphasis, reasonable steps, technical steps. First of all, technical steps might be how do we encrypt our data, and organizational measures, what measures do we put in place in terms of protecting? Is there a password system? Is there a 3-key system? Is there a double secure system in which people can actually access personal information? And that to ensure this protection is in place. However, POPI does not make provision for the resources of your organization as well as the nature of the information itself, stating that this will be taken into account when deciding, again, what technical and organizational measures are reasonable. And that one, we need to do a risk assessment. We need to perform a gap analysis to find out what measures are we going to put in place that is reasonable for the organization to protect their personal information. Why should your business comply with POPI? In terms of Section 19 of the POPI Act, you must secure the integrity and confidentiality of all personal information in your processing or in your possession or under your control by taking appropriate, reasonable, technical, and organizational measures to prevent any loss or damage to or unauthorized distraction of personal information. We cannot just throw papers in the dustbin. There should be a process like shredding or a shredder, outside shredder, that is distracting our personal information and documentation. And unlawful access to or processing of personal information. Leaving my computer unmanned and no password protection, having all sorts of papers around my office with all sorts of information is just a leak, and it's not if we're going to have a breach, it's when we're going to have a breach, because we're working with humans and human error is evident. Why is it important? Starting your company efforts as soon as possible. POPI is principle-based. That means organizations must each create their own effective and appropriate privacy policy and practices in order to protect personal information of data subjects at all times. So it becomes your responsibility, your accountability, your liability as business and business owners. And employees obviously has got a huge role to play in terms of safeguarding any information or any breaches of any information. Organizations further must also provide evidence of their efforts. So if the regulator, if there's for instance a breach and you cannot prove by any reasonable doubt that you've got checks and balances in place to protect, and for instance you've got nothing, you haven't got a privacy policy, you haven't got a cookies and website policy, you haven't got a service level agreement with a third party that is saving your documentation in cloud, you haven't got an addendum signed by your employees, what is your efforts in terms of safeguarding? Organizations is accountable, a big word. The organizations, when we refer to organizations, we will then refer to the CEO, who actually is the head of the business. Controls and notifications, what should be in place? Organizations will need to protect personal information using appropriate security. So what is the security measures in place to protect personal information? Notify authorities of personal information breaches. So at the end of the day, whether it's one breach, a small breach, you have to notify the regulator that there was a breach. And then obtain appropriate consents for processing information, whether it's your client, whether it's your customer, whether it's a third party, or whether it's your employee, we need to get the consent that we can process personal information. And then keep records detailing information processing. So what is our records of how we're dealing with acquiring any personal information? Right, so ladies and gents, let's look at the personal privacy and protection of the individuals and their rights. That is your data subject, normally your employee. They've got access to their personal data. That's their right. If they ask for it, they've got the right to access their personal data. What you keep, what type of data you keep, for how long you are keeping it. And they can also request for the correct errors on their personal data and making sure that any data errors are corrected, and ask for the erasing or destruction of their personal data. And as said previously, obviously there should also then be an end to the employee and employee relationship as and when you need to erase their data. And they might object to the processing of any of their personal information in the event of asked by a third party, or there's a request for data information, and only as and when, as stipulated by POPI, you're allowed to then process that information, and only then you're allowed to actually process the information as stipulated by POPI. Transparent policies and procedures that needs to be in place. The organizations are required to provide clear notice of information collection. So how do we collect information? Are we doing it electronically? Are we doing it paper-based? Outline processing purposes and the use of cases. So what do we do once we have collected the information? How do we process it? Again, electronically, manually, do we make use of a third party? And then define information retention and deletion policies. So how long do we keep records? Why do we keep it for that period of time? And in the event of deletion, how do we delete? How do we extract those records? And that should form part of your policy. Information, technology, and training. The organization will need to train privacy personnel and employees. So you're going to have some kind of a committee dealing with personal information, but also all employees, because you leave yourself open in terms of employees not trained and not following protocol in terms of your privacy policy. Audit and update information policies. How often are we going to audit and how often are we going to update our privacy policies? And then, most important, appoint an information officer with a mandate, with a job output or job description that is required from the job or the information officer. Now, the information officer is normally referred to as the head of the organization, that he can delegate some of his responsibilities to someone overseeing the information in the company, that he cannot delegate the accountability. And then create and manage compliant vendor third-party contracts. Again, if you make use of a cloud-based service where you save your data, how do they safeguard your personal information? And do you have some kind of an indemnifying clause that safeguards you in the event of this breach? And just not long ago, we can use some of the major banks in South Africa. has been breached. Last year, Facebook has been breached. And I think in 2018, a huge breach in the Yahoo accounts was breached. So how do we indemnify ourselves if there's a third party involved? Then protection of personal information, again, the potential impact of the employment relationship. Potential questions relating to the employment relation that arises as a result of the provisions of POPI is, first of all, is an employee entitled to ask to see a reference before it is sent for a prospective employment or employer or going for an interview? Can an employer conduct a credit record check on an applicant? Can an employer engage a third party to conduct a criminal record check on its behalf? Or can an employer transfer employee information to its holding company in a country that does not have the same or similar data protection laws? So on the end of the day is, if I want to go cross-border to a different country with my personal information of employees, am I allowed to do it? And what does my privacy policy allow and not allow to do? So ladies and gents, protection of personal information. Again, what is personal data and what is information, and just a few examples. The list goes on and on. First and foremost, an employee's personal information may include, for example, remuneration and bank account details, medical aid number, fingerprint for access to the employer's premises, which will refer to biometric information, performance reviews notes, even those notes that have been made by the reviewer himself, a set of completed job applications, or emails relating to work incidents. And then question, do employers have rights under POPI? Yes, you have rights in terms of data information, and we'll be looking closer at those at a later stage. What are the role players? Data subject, the employee, client, supplier, third-party information, anything you gather which does not belong to the company is seen as a data subject. Your responsible party, which is normally the organization, the employer or holder of any information, which decides the purpose of data processing and further the way in which the personal data should be processed. And then operator, that's normally your third-party service provider. As said, could be a cloud provider. It can be a person that is performing your e-commerce site for you, processes personal information for a responsible party. So in other words, your organization in terms of a contract or a mandate. And then the information regulator, which is the watchdog in terms of making sure that there is compliance in terms of all the requirements of POPI. And lastly, your information officer, as said, normally the head of the organization, which has been formally appointed on a letterhead with a mandate, with a job output, and with certain responsibilities. Question, are any of the above role players required to register? And we will discuss that later. What is processing? Processing is anything that is done with personal information, including when I collect data, anything about the organization, how do I store my records, and do I make use of storage facilities? How do I disclose information as and when requested by a third party or even by a data subject? Transmission, how do I transmit? How do I carry forth as and when there's a requirement for transmitting email, internet, for example? What do I use the personal information for? And do I stipulate that in the addendum of my employment contract as well as in my privacy policy? Question, will POPI apply in relationship to a contravention between two colleagues in respect of the views of their fellow employees' performance? Obviously, you are not allowed to disclose any information about anyone unless you have got consent. So in the event there's a performance appraisal done between supervisor and employee, that would be fine because there will be a consent. But 2 employees or fellow employees, that is a no-go. Further question, would POPI apply in due diligence exercise where the details of employees' remuneration? Would POPI apply in due diligence exercises where the details of employees' remuneration is processed, but employees' names have been redacted? Also, we can have a discussion on this at a later stage. What is processing continue? POPI will only apply to the process of processing of personal information entered in a record by an automated or non-automated means, so manually or by means of electronically. Where the employee is domiciled in South Africa or is not domiciled in South Africa but makes use of an automated or non-automated means in South Africa. So, meaning I have to register, for instance, a visa, people collecting personal data and information. POPI will not apply to the process of personal information, and remember in the previous slide I said you can actually say no to the collection of data or to the provision or making provision of supplying data. Now, where can we not do it? It is for personal or household activity. It has been sufficiently de-identified, so we have de-encrypted so that you cannot identify in terms of personal information. It is by a public body or for the purpose of national security. It is performed by the cabinet or it relates to a judicial function of court. So in the event of a criminal civil case, you have to give out personal information. Conditions for lawful processing. In terms of POPI, there are 8 conditions for lawful processing. Now we come into the real requirements of what POPI needs organizations to have in place. First and foremost, it talks about accountability, assigning ownership in your business, and that is having the information officer signed formally on a letterhead with a mandate, with a job description. And with accountability, another word that comes up is liability. So who's taking ownership of data and data breaches within your organization? Second to that, what is the purpose specification? In other words, the processing of information for lawful reasons and in a matter that does not infringe privacy. So why am I collecting ID numbers and names and birth dates and the information required from an employee? And am I infringing on their privacy when I do get their personal information? Then again, processing limitations. Only obtaining and holding personal information for a specific purpose. So I'm not gathering information to give out to a third party or direct marketing company or for any other purpose than for employment, for instance. Further processing limitations. Further processing of personal information must be compatible with the purpose for which it was collected. In other words, if I have collected personal information for payroll purposes or for South African revenue purposes or for medical aid purposes, that should then be used only for that purpose. Information quality. Information is completed and accurate. What is my process and what does my policy say in terms of my employment contract? What does it say in terms of updating personal information, and is it up to date? And what is the process to make sure that all information processed is accurate and up to date? Openness, being honest about collection and processing. That's why we sign the addendum letter with our employees, so that we are open about it for the reason why we're collecting the data and for what reason and for how long we're going to keep the data. 7, very important, security safeguards, using again the big word reasonable, technical and organizational measures. In other words, do we encrypt? Do we have policies and procedures in place? And are our employees trained in terms of personal information and the protection thereof? And then lastly, our data subject participation. An individual may request information is accessed, deleted, or corrected. So obviously, data subjects have to have the ability to also participate in the POPI compliance. Justification for processing of personal information. In terms of POPI, can an employer conduct a credit record check without a job or applicant's consent? Will an employee be able to process an application for an income tax directive? Can an employer disclose an employee's personal information, for example, their bank details, to a payroll provider? Again, questions, no. Permissible grounds on which personal information is allowed to be processed. Consent by the employee, by the client, by the supplier, by the third party. The processing is necessary for contract to which the employee is a party to. There is a legal obligation to perform processing. In other words, there might be a criminal case, there might be an accident. In case where one of your employees was in a serious accident and they cannot talk for themselves, in that case, there might be a legal obligation in terms of getting an ID number, phone numbers, and detail to possibly save a life. Protection of a legitimate interest of the employee. For instance, South African Revenue Services, and by public law duty by a public body. Necessary to pursue the legitimate interests of the employer or the third party. So what is going to be the interests of the employer or the third party in terms of pursuing legitimate interests if I'm actually handing out personal information? Then special personal information. POPI Act refers to special personal information. Just a few examples. It refers to, can an employer require an employee or job applicant to undergo a medical test? Now, if we refer back to the Employment Equity Act, there's also a clause in terms of medical testing in there. Can an employer conduct a criminal record check without employee's job applicant's consent? Can an employer upload photos or its employees on the company's website or on social media platform? Again, this refers to biometric data. You've got surveillance cameras all over your premises. You caught a guy red-handed stealing. Are you allowed now to use that surveillance without the consent of the employee in terms of a disciplinary inquiry or possibly referring it to the police? Special personal information. Again, the categories of special personal information include religion or philosophical beliefs, race or ethnic origin, trade union membership, political opinion, health and sex life, biometric information as set your photo or surveillance or even voice recording, and then criminal behavior. So we're not supposed to disclose any of these unless it is by law required to disclose this information. Processing of special personal information is prohibited, again, unless the employee consent to the processing. So there's a consent, and as said previously, done in writing. The information has deliberately been made public by the employee. So as and when, for instance, when I send out emails, I've got my telephone number, I've got my name, I've got my website, so I'm deliberately actually giving it out for the purpose of possibly marketing purposes. The processing is necessary for establishment, exercise, or defense of a right or obligation in law. Again, as and when the courts might require certain information, it is lawful. And the processing is necessary to comply with an obligation of international public law, as and when there is a breach in terms of the international public law. The processing is for historical, statistical, academical, or scientific research. So when Stats SA comes around and they want information for statistical data that is allowed to give out the special personal information. Then the regulator has granted authority for the processing in the public interest, and there are appropriate security safeguards in place, or it is in accordance with the specific circumstances prescribed by POPI Act. So that is the grounds for disclosing any special personal information. Again, if I'm disabled, am I allowed as employer to disclose that information to any third party unless with the provisions as said? So yeah, let's look at the rights of a data subject or subjects, that's normally your employees in terms of POPI. Question: is an employee entitled to ask to see a supervisor's handwritten notes from a performance discussion or performance appraisal? Answer is yes, because that is personal information from a certain data subject. Can an employee request an employee to make changes to a reference on the basis that it's inaccurate? If there's inaccurate information based on the data subject and a request is made to rectify that, yes, you must. And then lastly, what if an employer's HR representative mistakenly misplaced potential candidates' CV? Obviously, that is a huge breach in terms of data information, and that can lead to transgression or to possible regulator that is doing an inspection of why the candidate's CVs has been misplaced or let lie around for everybody to see. So we need to be very careful in terms of that personal information. So ladies and gents, what then is the rights of a data subject or subjects in the event of a data breach? An employee has the right to have his or her personal information processed in accordance with the conditions for lawful processing. Again, emphasis lawful, including the rights to inter alia and, amongst other things, be notified as and when information about him has been collected either by a public body or by a third party, or has been accessed or acquired by an unauthorized person. And if we refer to our previous examples, CVs that were laying around and somebody unauthorized got access to that personal information, you have to notify the data subject. To establish whether his or her employer holds information about the employee and requests access to such information. Now, if you've got a POPI manual on the grounds stated and stipulated, you can refuse based on your policy and procedure in terms of personal access to personal information. The data subject to request the correction, distraction or deletion of his personal information. Now, the assumption is correction is one thing, but distraction and deletion, the assumption is then that the employer and employee relationship has come to an end. And then to object on reasonable grounds to the processing of his or her personal information, I suppose, as and when there's a third party that wants to make use of personal information for direct marketing purposes, that could be reasonable grounds. And then lastly, very important, a data subject can submit a complaint to the regulator to institute civil proceedings because of the breach of a certain data subject. So please bear in mind, a complaint can be launched to the regulator for further investigation. Transferring information to other countries. So that is your cross-border transfer in terms of POPI. Under what circumstances can an employer send the personal information of its employees to its holding company, say in the USA or in the UK? And can an employer store employees' personal information on the cloud? So again, it might be I'm using a cloud services based in the UK or somewhere in Europe, and can I store the information there? Again, transferring information to another country. Transborder information transfers are prohibited unless such transfer falls within the ambit of the following exemptions. So can I, in terms of my two previous questions, where the receiving country has similar laws in place or is subject to binding corporate rules or by binding agreement concluded between the sending employer and receiving employer that provides for an adequate level of protection, substantively similar to that of POPI. So if there's an agreement in place of how you're going to safeguard this information, you can then do it. Again, the employee's consent. The transfer is necessary for performance of a contract to which the employee is a party. So, for instance, if your employee has been dedicated to go work overseas for a month or two on a special project, which links to the contract, that can be done then. The transfer is necessary for a contract in the interest of the employee. The transfer is for the benefit of the employee and getting consent is impractical. So as again, my example, if a person is in an injury, cannot talk or do for themselves, and I really need personal information to actually save this person's life, then I can actually transfer that information. Question: can an employer transfer medical results to its holding company in a foreign country that does not have adequate data protection laws? On the end of the day, question: no. So ladies and gents, let's look at some steps in terms of complying with the requirements of the POPI Act. Remember, there's a transition period started in July 2020. We've only got 6 months time left. That leaves us actually no time for full implementation and full compliance with the POPI Act. We need to review and develop standard clauses around data protection in employment contracts, making sure that our employees have signed consent forms, making sure they've signed that they understand policies and procedures, and that we've got workplace policies and procedures in place. And in my next video, I will compilate a whole list of the policies required in terms of the Act. We need to conduct an audit as to what personal information is held, where it is held, and by whom it is held. We need to establish what personal information is collected in one place and transferred to another in the event of we making use of a third-party provider like a storehouse or somebody that is collecting our data and store it somewhere else. We need to develop a group-wide standard data protection policy in the event of we are working in a group of companies, policies and protocols if not already in place. We need to establish means to comply with any notification requirements. So as and when the regulator makes out a notification to the company for non-compliance, we need to have a mean of how we're going to comply to that notification. Very important, we need to appoint an information officer firstly, and then deputy information officers for the purpose of POPI and Papaya. Now, the reason for this is that the information officer might not always be on site. It's typically like your 16.1, 16.2 in occupational health and safety. Bear in mind that you can delegate responsibility authority, but accountability will still lies with the first information officer. And lastly, we need to develop policies around retention and destruction of documentation as and when required. The purpose of the appointment of the compliance officer: to give effect to the right to privacy in terms of our common law, Section 14 of the Constitution, and the purpose and application of the Protection of Personal Information Act number 4 of 2013, especially to implement and maintain the provisions of POPI Act, including but not limited to the following: to give effect to the constitutional right to privacy by safeguarding personal information when processed by a responsible party. Responsible party, again, referring to the organization. So in other words, the mandate stroke output expectation of the compliance officer is to make sure that we can safeguard and have privacy to personal information. Secondly, to regulate the manner in which personal information may be processed
Again, how do we process it? Where do we store it? And by establishing conditions in harmony with international standards that prescribe the minimum threshold requirements for the lawful processing of personal information, especially as and when we go cross-border. And lastly, to provide persons with rights and remedies to protect their personal information from processing that is not in accordance with the Act. So, for instance, if there's a breach, what rights does the data subject have in terms of the processing of information and it leaked or it was breached? Failure to comply with the Act, obstruction of the regulator, may lead to imprisonment of certain penalties under the Act. Punishable offences in terms of the Act, the following offences are committed. If committed, punishable with either a fine not exceeding 10 million or imprisonment for a period not exceeding 10 years, and very important, both, depending on the severity of the breach. Again, when is this applicable? When we obstruct the regulator, failure to comply with enforcement or information notices, again, as and when there was a breach and we've got a notice, a notification, and we don't deal with that notice. Offences by witnesses, giving false evidence before the regulator. In other words, my employee is not true and valid as and when interviewed, or an officer, and lawful acts by a responsible party against company in connection with information and or the usage thereof. And lawful acts by a third party in connection with information usage. Your cloud provider, you're saving documents, there's a breach, to sell it to another third party for direct marketing purposes. And then any person who offers to sell information or obtain any information illegally. Failure to notify the regulator that processing is subject. In other words, we're not allowed to process information if there's failure that we haven't been notified. And then breach of confidentiality. My suggestion is that there should be a confidentiality clause in any of your third-party agreements that you will safeguard their detail and personal information, and they must safeguard your organization detail and information. And then obstruction of the extension of a warrant due to the fact that there was a breach, due to the fact that there was notification or there was enforcement applicable, and now there's a warrant and you obstruct the execution of that warrant. POPI Act impact areas to other parties of personal information, appointment of information officer, the company newsletters, notice boards, company secretary, competitor information, compliance audits, consent records, denial records, contract information, contractual agreements, creditors, day-to-day email and other communications, debtors, document retention periods, general accounting system including payroll, government and community relations, human record keeping, attendance records, insurance and medical policies. So the list goes on. Legal affairs, maintenance records. For instance, you sent your vehicle for maintenance at because it's a maintenance service level agreement at a certain supplier. That supplier, the driver that's going to deliver the bakkie, what's the driver's telephone number. So on the end of the day, you start giving out personal information, and what are you doing with those? Marketing, including implications for documentation and online resources, media and public relations, newsletters to subscribers,
on-site and off-site information storage, other relevant legislation, your Consumer Protection Act, Labor Relations Act, Occupational Health and Safety Act, Skills Development Act, your UIF Act, POPI manual, making sure that there's personal access to personal information should incorporate all the regulations and the requirements of POPI. So you need to update that manual. Personal information distraction policies and procedures. So how are we getting rid of documentation or of records once a relationship has ended or once a time lapse has been reached? Policy management. Who's responsible for drafting the policy and for updating the policy, for training employees on the policy? Your privacy notices on your website, on your emails that has been sent out or are being sent out. Safety and security, including access control. I mean, on the end of the day, who's got access to what type of information, and what is your systems in place to make sure that there's no breaches. Sales, including records, management proposals and contracts. Service agreements, in particularly the IT outsourcing department where you make use of a third party looking after your IT, looking after your cloud storage, etc. Surveys and competitions. Time management systems, for instance, your biometric, where people have to show their fingerprints to actually get access to your premises. How do you control that, and how do you safeguard that information, because it's all converted to some sort of data and some sort of information. Your website, and how secure your website, and what type of detail and personal information have you got, and have you got your privacy again, areas affected by POPI. If we look at this slide, again, we collect, then we store, and it can be electronically, it can be offshore, it can be onshore, it can be at a third party, it can be at our premises, it can be electronically, it can be manually. The question is, how do we safeguard that information? If we want to retrieve, what is our policies and procedures in terms of retrieving? Because if we do store it off-site and we need to retrieve certain documentation, how do we safeguard our documentation in terms of the courier company maybe traveling between A and B, and how do we safeguard that documentation and information is not going or is not breached? Then the usage of that information, again, for what purpose do I require certain information, and what am I going to use it for? And I need to use it for the intention eventually or initially actually acquiring the detail for. For how long am I going to retain documentation, personal information, and how am I going to destroy any personal information, any personal documentation, or am I merely going to throw it in the dustbin and hope that nobody sees it? What action is required? A comprehensive review of the current state of compliance, a gap analysis, a questionnaire. To the listeners, to my audience, I have developed a questionnaire, 28 questions, in which you can determine your gap of the requirements that is still not fulfilled. Please do complete this questionnaire, because it will give you some insight as to where you are within the process. Remember, we've only got 6 months left in terms of implementing and making sure that we are in compliance with all the requirements. The gap analysis will typically reveal one or more gaps between the current and required level of the compliance, and it will give you the resource for building the bridge and making sure that these gaps are filled. And again, it should be reasonable and appropriate. That is key in terms of anything you do. All policies that is going to be put in place must revert to the reasonable and appropriate to your organization and to your operations. You cannot go and download a document from the website and say, there's my privacy notices and my privacy policies. It is what is happening on site, what is happening at your premises and at your organization. Again, practical examples of data breaches. Not too long ago, it was in the news and it was listed also in the Citizen. Chief Justice Mogoeng's offices, it was burglared. Now, when we refer to the offices, it was actually the courtroom. The computers in the human resources units, which contained important information about judges in the country, officials in the offices of the Chief Justice, the Constitutional Court, High Court, Supreme Court of Appeal, and other specialist courts were stolen. Now you can imagine this breach, and how do you deal with such a breach? Points to ponder in terms of this case scenario. Was there a risk assessment done, and was a risk assessment implemented, and was employees trained on all the risks and how to mitigate all these risks in terms of the breach of the data as stipulated above? Again, security policy, and was there a breach in terms of the security policy? And was there a security policy? And have the people been trained, all employees been trained on the security policy? What security measures was in place? I mean, was there a two-lock system, a two-check system, or is gates just open randomly for anybody to enter? Was the protocol being breached in terms of the security measures that has been in place? Again, training. You cannot emphasize training too much, because this is where people go wrong, because it's easy to say, I did not know. But if I can prove that I have trained you and you have breached any security measure or any risk assessment for that matter, any policy, I mean, that leaves itself open to or for disciplinary action and for corrective action. And then threat monitoring. How did they monitor their threats, and how did they update their monitoring equipment and processes? And was their monitoring process in terms of threats in place? And what was their process in terms of data recovery? I mean, if files were stolen, do they have all these also in an electronic form so that they can recuperate any data that was lost? Or was it only hard copies? And now that hard copies is gone, and all personal information is also being breached in terms of the documentation that has been stolen. And what is my data loss management policy? And how do I recuperate in terms of data loss? And again, did I report it to the regulator? You can go and check this or see this link, and it will refer to the above data breach case. Now, in terms of my next slide, I would like to for you to pause now, take a break, and earmark all the data breaches and non-compliant issues in terms of this picture. So take a few minutes, have a discussion with your colleagues, and when we come back, we'll have a look at the various places where possible data breaches can take place. So please discuss in your group, discuss with your fellow employee, and I'll come back and we'll identify the places where there's possible breaches for the breach of personal information. All right, ladies and gents, welcome back. Let's look at a few examples in terms of data breaches of the specific office. First and foremost, if we look at the dustbin, I mean, what type of personal information could possibly in that dustbin? Maybe that dustbin is set for the shredder, but at this point in time, it's data that is available for everybody that's walking past, and can be breached. And let's say you've got a cleaning company, a third-party cleaning company, and one of their employees is paid to get subject matter data. That is one thing for that person to empty that dustbin, and they've got a lot of personal information. Second to that, I mean, what is in that case? It looks like a laptop case, but what personal information might be lurking in the laptop case? Again, I'm not too sure what could be in that box. It could be business cards, it could be photos, it could be anything value of personal information. Your notice boards and things pinned to your notice boards, telephone numbers, figures, maybe reminders, maybe financial statements, anything just to remind you of not forgetting to do certain tasks might be a breach in terms of personal information. Again, sticky notes that might have telephone numbers, ID numbers, or any personal data on them. Your files, what is in your files, and why are files not protected or stored in a safe place like a safe? Your telephone, have you got a PIN code to log onto your telephone, or can anybody pick up the telephone, see what was the last number dialed, go into your address book, and there's a data breach in terms of telephone numbers. Again, filing system, we've spoken about that, and then you've got your card system, whereby you've got all supplier information, customer information. It's all open for anybody to look at, anybody to grab and steal it, and there's a breach in terms of data information. Very important, your computer keyboard and your computer screen, and notes pasted on your computer. Again, very important. Why is the screen not password protected? Why hasn't it got a 1 minute or 2 minute lapse time if you're not at your working station, that it automatically shuts down and you have to enter a password? Why is personal information so evident and so easily accessible for anybody that walks past? Again, your computer, is it secured, or can I unplug and can I actually steal the computer box or take out the hard drive in terms of accessing personal information? And personal information is not just referring to a data subject, it can also refer a data subject to the organization's detail and personal stuff that is on the computer. Again, printer, what has been printed? Was it financial statements? Was it an ID? What has been printed and just lying there for anybody to access? Your notes on your whiteboard, is it personal information? Does it protect your data subjects? Or what type of information is discoverable in terms of the whiteboard? Again, clipboard, what is on the clipboard? Again, could it be performance reviews? Could it be a job interview? What could be possibly on that clipboard that can breach personal data information? Your filing cabinet, there's a key. It's supposed to be locked. The key is in the lock. Somebody can walk past, open the drawer, and just take whatever they want to in terms of personal data. And again, the drawer is open. Why is it not locked and closed? Again, access to personal information for anybody that walks past, and then can get access to personal information. So ladies and gents, you can see anything that can lead to a breach of personal data and loss of personal data. So we need to become vigilant with our employees, vigilant in terms of our policy and our security, and making sure that all personal data is securely and safeguarded for any person to actually breach this type of information. I hope that you will be able to find most of the data breaches, and again, make this as a mental note, so that as and when you start implementing your safeguarding and your policies and training your employees, that you make them aware of possible breaches. Further, what you need to do about data privacy and the POPI Act. The board or top management, it's their responsibility in terms of governance, making sure it starts with them. It's a top-down approach. and they are influencing and they are involved in terms of the process. Your board or top management needs to set direction and provide oversight in terms of what is going to be your external and external audit processes, your information and record owners, and who you're going to make use of, your service providers, third parties, you're going to make use of in terms of safeguarding your documentation, safeguarding your personal information, and ultimately your employees, that they are trained and that they are familiar with the policy, and in the event of any breaches on their side, that there's repercussion in terms of possible disciplinary action, stroke criminal offense. Look at your risks and value your risks in terms of your severity, your likelihood, your frequency, and how often, what is the chance it's going to happen, and what is the seriousness if and when a data breach does take place within your organization. You have to take a long-term vision. It has to be externally orientated view in terms of how you're going to safeguard your personal information of your data subjects. And hold ultimate accountable and liable to external and internal stakeholders. So, in the end of the day, if there's a breach, the company information officer is going to be held accountable and liable for any breaches. Now, if we look at the next slide, we're talking about Central Data Info Management Unit. It might be that you are working in a group of companies and you are storing your data in a centralized area, or it might be that you store it on site, doesn't matter. You have to align your job function to the information access. So whoever has got access to information, we have to align the job function in accordance with that. We need to reduce the amount of information collected. So if I don't need an ID number, don't ask for the ID number. And I refer to this as, if I've got access control, I'm working in an office park and I need access, and my customer needs access, why do I need to ask for the ID number? Is it necessary to ask for the ID number? What am I going to do with that ID number? It might be more appropriate to ask for a telephone number, but again, we need to start looking at our processes and what type of information and how can I reduce the amount of information I require. Closing many access points of information. Again, your policy should make provision of where is all the entries of information. Is it the recruitment officer, the HR officer, the safety officer, the access control point, and how can I reduce access points of information? And then provide information security awareness training, making sure training, retraining of security breaches that might take in my organization. And then again, reduce staff access to information. Who has got access to the safe? Who has got access to personal information? How do I safeguard that information? And what is my company culture in terms of safeguarding any information, especially when I leave my workstation and I leave myself vulnerable for data access breaches. And lastly, contractual agreements with service providers who process information on behalf of the institution or the organization, and also adhere to the POPI Act. So any third party that is involved, whether it's cloud-based, whether it's people storing your data, whether people is couriering your data, you have to make sure that you've got a service level agreement in place and an indemnifying clause that as and when there's a breach, that you've reasonably, technically and organizationally done everything in your power to safeguard your information. And again, I want to emphasize, if you've got a contract and I stipulate certain things on my contract, you need to also visit the site, visit the third party to ensure that what they say on paper is actually done on their site to safeguard information. Don't take it for granted that you've got a service level agreement in place. It's signed. It's just a piece of paper. You actually need to go and make sure that you've done your checks and balances, and you visited the third party, and that they are actually in adherence with the requirements of your service level agreement. In conclusion, the protection of personal information isn't a choice. It is the law, and it will become law the 1st of July 2021. We are all affected. Again, one-man show, employing 50 people, employing 100 people, 1,000 or 10,000 people. We are all affected as and when you actually acquire any personal information. Please refer all questions to cars@businesscompliance.co.za once you have looked at the video, and please post all questions, because this is not a live webinar. This is a training session. So if there's any questions, please refer it to this email, and as and when I get time, I will revert to answers and come back to you. And my promise, I will answer all questions as and when time allows. I want to say thank you for listening, thank you for your time, and thank you for making this possible, and thank you for being compliant as and when time arrives. Again, myself, J.A.P. Kokemoer and Associates, at your service for your business compliance. Thank you for attending this training session. And lastly, please, as and when you do training, you have to make provision that you've done training and have a signed attendance register, that you can prove that you have trained, you've been trained, your employees have been trained, and that there's no questions being asked that, yes, we have trained our employees, but what is the proof if you cannot provide proof by means of an attendance register? So please do sign your attendance register. Thank you once again. See you in the next video. My next video will deal with what is the way forward, what needs to be done now, what steps should be taken in terms of implementing, in terms of getting to a policy document, getting to our SLA agreements, making sure we've got a cookie and website policy, making sure we've got a data retention and a distraction policy in place extra. So my next video will deal with those to actually guide everyone through the process. Thank you for watching. See you in the next video.